Welcome back to This Week in Immigration. I'm your host, Blake Johnson. This week, we'll get an update on the situation with the Afghan refugees and the history of Special Immigrant Visas, featuring BBC fellow Ruth Wasem. Then, we talk about the State Department's visa backlog and the risk of wasting up to 100,000 green cards this year. Finally, we're back in court for another segment of the Gavel, where we will review the Migrant Protection Protocols program and what happened at the Supreme Court and what it means for the administration. All this to come, so stay tuned. In last week's episode, we talked about the Biden administration's withdrawal from Afghanistan and the collapse of the Afghan government. This week, we are joined by BBC fellow Ruth Wasem to discuss the origins of the Special Immigrant Visa, or SIV program, for Iraqi and Afghan translators and its expansion. Ruth, welcome to This Week in Immigration.
It's a pleasure to be with you.
So, Ruth, can you give us a little history about the SIV visa program and how it started, and what's the origin here?
Well, there's always been a what that used to be called a non-quota category and was renamed a special immigrant category of lawful permanent resident visas for since the 1952 Act. And what happened really that's interesting about the origin was back in about 15 years ago, around 2005, 2006. There was a concern of that Iraqis and Afghanis who had worked for the U.S. government, particularly as working as translators, were in danger. And one of the ways we recruited people to work for us was to ensure they could come to the United States. The ability of people who were long-term employees of the U.S. government to come as special immigrants had been on the books already for about 20 years. And so they were looking for a category or a way to bring them in, recognizing at that time that they didn't qualify as refugees. So it's kind of prescient when you think about it, that there was this recognition that it wasn't necessarily safe in Afghanistan for people who were known to work for the U.S. government, but that they didn't necessarily meet the definition of a refugee, which, as our listeners know, is a well-founded fear of persecution based on 5 characteristics. So this visa was created expressly for Afghan and Iraqis who had worked for the United States as translators, largely working for the U.S. military, and was added and expanded over the years to what has become a major pathway today for Afghanis who are escaping and evacuating from the country.
So on that, to where we are today, can you talk a little bit about the process that's being used for them, how they apply and how they're exfiltrated, as far as what we're seeing?
Well, one of the things that's important to know, because this is a broad concern, and it's something that is in the excellent blog that BPC produced yesterday, and that has to do with the vetting process. So, and there's always a concern when someone's coming from a war-torn area like Afghanistan, that it will be, these pathways may be abused by people who would do us harm. So the first step is that the people who have already worked for the U.S. military and U.S. government, they were vetted to get that job. But if you are one of those individuals, you do a petition for this visa category, and you go through a rigorous petitioning process that includes getting the documentation from the U.S. military presence that you indeed are that individual who did serve in that capacity and are eligible for the SIV visa. Then, and you have to have worked for our armed forces for at least 1 year. It also, the category does allow for your spouses and children, young children, minor children, to be included in the category. Um, and you have to have a favorable written recommendation from the commanding officer or the general flag officer for the relevant agency.
So, and actually on that, I just curious, because you mentioned, for spouses of minor children, what does this do for intergenerational households who are in that situation?
Well, as is the case for all of our immigrant categories, we put a premium on immediate relatives, close family, spouses, and minor children, and that's built into our law. So if you have a grandmother in the household, an aunt or an uncle, or taking care of the children of a family member who might have died in the hostilities, they're not included in your visa application. So those other kinds of people have to try to seek relief on their own. Now, would they be eligible for a refugee visa? Would now that particularly the Taliban is back in control, I would think that would be a pretty compelling case to be a refugee if you are a family member of someone who is already eligible for an SIV visa because of your relationship with the U.S. government.
Okay, so if you didn't qualify for the SIV, but obviously the situation has changed on the ground and it's become a dangerous situation, what other visas are available to those Afghans who worked with Americans?
Well, again, it's the refugee visa would be the main one that you would apply for. And most of the people coming out of Afghanistan are applying, are going to Pakistan and Iran that are escaping as refugees. I mean, there are millions, as we know, and so the main way for them to get out of that situation is through the traditional refugee process. The SIV visa is a very unique, it's highly specialized pathways for those who worked with the United States and qualify for that. And that program had been backlogged for a while because it had numerical limits. And the program had been plagued over the years for being arduous and all the different requirements. So it's not something that is as elegant, if that's the right word, as our refugee programs, which themselves have long backlogs for people. So in all of this, when you're leaving that situation, between the vetting that's involved, the background checks, all the other screenings, as well as does the person actually qualify? But they are setting up other ways, trying to provide ways out for people that are eligible. There's pressure on to consider paroling individuals into the country. That's not a visa category at all, but just other kinds of rescue ways out. Certainly, things that have been used in the past is to, the first priority is to get people to safety. And then you can kind of sort through what visa they might be eligible and whether third country resettlement and what country. So this is all part of an international effort, not just now. United States arguably has a very special relationship here and a special responsibility.
Yeah, and so of the Afghans that we've seen in the photos that have come out of them landing in, U.S. airports and those brought, what's in store for them now? What's that process going to be for them now that they've, arrived at a U.S. airbase or even, at a third country holdings point?
Well, those that we can, that's the great thing about having the SIV. If we can identify people that are eligible for that visa, they can go that route. They'll be put in refugee processing to see if they're eligible for refugee visas and their families. It's my understanding that the Department of Homeland Security will be handling this resettlement, as opposed to traditionally, in the past, State Department has also been heavily involved. So I'm waiting to see how this all plays out. And of course, once they're in the United States, both SIV visas and those that are eligible for refugee status trigger involvement from the U.S. Department of Health and Human Services for refugee resettlement processing. So there's still a lot of bureaucracy in place and things to go through. But our military is playing a heroic role in first getting people to safety.
Ruth, thank you so much for that. And actually, on the departments and everything else, I want to bring in Teresa Cardinal Brown, Managing Director of Immigration and Cross-Border Policy here at BPC, to talk a little bit about this. Teresa, welcome back.
Hi, glad to be here.
We heard news today, this week, that DHS Secretary Alejandro Mayorkas has been put in charge of coordinating this resettlement effort that Ruth just mentioned. How do you see that playing out, and do you think DHS has the operational capacity to handle it?
Yeah, so what was announced is that DHS has been named the lead agency for what's called a unified coordination effort across the federal government over the resettlement of the Afghan evacuees. What that means is that DHS is coordinating between its own components involved, which include USCIS, which will include probably CBP as well, and the other agencies involved. So if we're talking about refugee processing overseas, that could be State Department. If we're talking about resettlement in the United States, that could be HHS and the Office of Refugee Resettlement. Obviously, the Department of Defense, that is, landing people at military bases here and overseas, also is playing a part with the logistics. It's mainly at that level, it is an operational coordination effort to deal with logistics, basically. So Secretary Mayorkas named a FEMA employee, a senior FEMA employee named Robert Fenton, to be that specific operational coordinator. So he will leave this, basically it's an interagency task force overseeing all of that. Now, within that process is the immigration process that Ruth was talking about, determining which of the individuals are eligible for what, and doing that screening and vetting, which also involves other agencies like the FBI and the Counterterrorism Center, as well as intelligence agencies. So, we flew a lot of people out of Afghanistan. Many of them were Afghan nationals. Many of them were citizens of other countries that involved in the coalition efforts in Afghanistan. Not all of them were in the SIV process or far enough along. Some of them may just have presented. Some of them may be looking to actually resettle with other countries that they worked with rather than the United States. So just kind of doing that sorting of who is who and who might be eligible for various things. The Biden administration has committed that people will be fully screened and vetted before they're flown to the United States. So those that have arrived so far are mostly, as we understand, although we don't have all the details, people who have gotten far enough along in the SIV vetting process that we're fairly sure that they are, who they say they are, and they're not a threat. Some also have been granted what Ruth mentioned was humanitarian parole, which is basically sort of like I'd say it's a universal default mechanism that says we don't have another category to give you right now, but we recognize that you have this urgent humanitarian situation and it's in our interest to let you come into the United States and continue there. One of the interesting things about this situation is, as Ruth mentioned, some people who did not qualify for SIV status or would not qualify for SIV status might be considered refugees once they've left Afghanistan. You can't apply for refugee status from within a country. However, if they've come to the United States, they now become asylum applicants because you can't apply for refugee status from inside the United States. And that is, I think, one of the key issues. You asked about DHS capacity. DHS certainly has the capacity to do this kind of coordination, especially FEMA. That's largely what it exists to do, is large event and response coordination efforts. But one of the key things that's going to happen now is the immigration part of this, the immigration system, is going to have to figure out how to enter everybody into the system and process them in some kind of fashion. And that's the next, I think, biggest hurdle.
So, back to that capacity issue, and ProPublica had a story out about Afghans who are now refugees, but had previously won the diversity visa lottery 2 years ago, but were never processed because of COVID, and our whole backlog within the immigration system, which I think we're going to be going through this today. How would you say the arrival of the Afghan evacuees will affect the backlogs that we've already got in place?
Yeah, I think that's the key issue. I mean, as Ruth mentioned, in the SIV program, prior to the withdrawal, there were approximately 80,000 estimates of people who have applied for status and who are somewhere in that process. A lot of the processing of visas, not just the SIV visas, but all kinds of visas, was shut down in 2020. And Afghans also were affected by the various visa bans that the Trump administration had put forward. So even SIV applicants were stuck in that backlog. So as you mentioned, folks who had won the diversity visa lottery from Afghanistan in 2020 were not able to process, both because of the existing travel bans and because of the COVID shutdowns of much of the system and the immigrant visa bans. So they essentially might have lost their chance, but for some court cases that ordered the government to process them, but they weren't put anywhere near the front of the line. And now that the situation has fallen apart in Afghanistan, they now have no other alternative probably other than to try to flee the country and apply for refugee status. So the convolution, I don't know, the integration of immigration law and backlogs and this sort of rapid fire, pretty much wildly chaotic Afghanistan evacuation is resulting in a large group of people suddenly being put into, as you mentioned, an already backlogged immigration system. And so the ability of the system to absorb these new numbers and process these cases in any sort of timely fashion, I think that's seriously questionable, honestly, without an additional serious infusion of resources.
Well, and I think we'll just take it from there, and let's go and take a look at some of these other processing delays for visas that we need to look at that are currently going on, namely 100,000 green cards for applicants are about to expire and be lost. We'll take that up next. So we're going to turn now to Sadiqa Nepal, who's our BPC fellow, to discuss the lost visas. We know about historic visa backlogs at the State Department and at U.S. Citizenship and Immigration Services, but for our listeners who don't know, Sadiqa, can you give us a little context of what these backlogs are and what's at stake here?
We've talked about this quite a bit in our blogs as well. And I've written about this. Currently, we have 1.2 million primarily Indian nationals in green card backlogs. And usually the backlog is already really long. So, some of these folks have probably applied for their green cards in early 2000s. There are some statistics that suggest that if they were to get in line now and there was no intervention in the system that we currently have, that their backlog could be, or their wait time could be as long as 89, 90 years. So we can imagine that it could be very frustrating for this community that this is happening. And so what is actually happening, to give a little context, is that due to COVID, a lot of consulates and State Departments had closures and they were not able to process all of the family-based green cards. And so there were, by October 2020, like around 120,000 leftover green cards from family-based immigration that rolled over towards employment-based immigration for green cards. Usually we give around 140,000 green cards per year, and there is a 7% cap. a global cap. So it's very complicated, and populations that have a huge representation in the United States, like those from India, they have really long wait times. So this 120,000 green cards that became all of a sudden now available is really sought after. But because of the COVID-19 backlogs in State Department, USCIS, there's biometric delays. Those 120,000 green cards, out of that, 100,000 are set to expire at the end of September. By set to expire, it's like they're not going to be able to use it. So it's going to get recaptured back by family-based immigration. And Teresa has a good analogy of it, so I'll leave it up to her to explain later on. Average green card application times have gone up significantly. Currently, it takes like 10.5 months for them to get a green card. And if they are not able to process the green card now, it's not like next year their number is going to be at the top of the line again. They are going to be in place for a green card, but that wait time can be significantly high and could be 5 years. During that period, these folks are in temporary visa statuses. They have a green card, but they've been approved for a green card rather, but they haven't received one. And their children, if they are to reach the age of 21, they can age out of status category, which means, like, say, if they had moved here in 5th grade or when they were 2 or 3 years old, all of a sudden, they're undocumented. They have to go back to their country of origin, or switch visas to an F1 if they're in school, so on and so forth. So it can make things complicated, not just for the principal visa holder, but it has a lot of ripple effects. And because the wait time is so long, this overflow of the visa was so coveted. So it's very frustrating to watch this snail pace sort of USCIS functioning of this, knowing that the population that's waiting for it has needed it for so long.
So Teresa, sort of as we're bouncing back and forth between these buckets of potential visa cards that are available yet cannot be processed by the State Department, to help people just understand, to give an analogy, what would this be like?
So we talked about this earlier, and I think this is the best analogy I can come up with. I'm sure other people have others. But think about there's a music concert that's very highly coveted, and there's one line for VIPs to get into to get tickets. And there's another line for sort of everybody else. In this case, the VIPs are the family, because our system preferences family-based immigration first. And because of, you have the VIPs have a certain amount of time to process their visas or to process their tickets, to get their tickets online. But because the system is so slow, not all of them are able to get their tickets in their available window. So then those tickets are opened up to the non-VIP line. So all of the people who were waiting in the non-VIP line for however many tickets were available, let's say there's 2,000 tickets that are suddenly dumped on that line. That means 2,000 more people in that already existing line have a chance at getting in. But the system is slow for them too. And not all of them can be used in the window they have. So guess what? They go back to the VIP line. So suddenly, an additional 2,000 people thought they were going to get in, and now they have to wait and may or may not, right? So they didn't lose their place in line. Their line is still the same, but their ability to actually get to the front of that line has just changed because the number is available. And that's the way our system is designed. And most years it's not really an issue because all of the visas that are allocated for family-based are used by the families. And so the employment-based get their 140,000. Occasionally there's this unused visa queue. More often than not, employment-based visas go unused and roll up to family-based than the other way around. Almost always, most of the family-based are used and employment-based sometimes go unused. And there are estimates that over the last maybe 10 or 15 years, another 100,000 visas just were wasted by not being able to get processed. But what happened with 2020 was unique in that the number of visas in 1 year is about 100,000. So when we say they're lost, they're not lost necessarily completely. But let's go back to the backlogs in the system. in addition to the wait times because of the caps on the visa categories, our entire immigration processing system, the adjudication of cases at USCIS, the visa application process at consulates overseas is completely bogged down because of COVID closures and some rule changes that the Trump administration put in place that haven't yet been completely undone. And so they've accumulated a long backlog of cases they haven't yet decided. And so it is very likely that this lost visas could continue year after year, flip-flopping between visas in the employment-based category and the family-based category for several more years, unless somehow the system gets another infusion of resources. And we see sort of COVID reopening more broadly.
So looking at this, this population and, this backlog, which predates COVID, obviously, and is, an issue that has long been felt by these immigrant populations who are, talk about doing it the right way. What is Congress doing on this? Are they taking this seriously? Are they trying to find ways, maybe surging resources, staff, personnel, processing capacity, digitization, ways to speed things up?
Yeah, so it's interesting because on the family-based immigration visa side, actually, there has been a system to recapture unused visas, and on the employment-based visa sides, that has not passed. Congress has attempted several bipartisan bills in the past, and one of the popular ones that we've talked about and written about at BPC, the Fairness for High School Immigrants Act, it passed unanimously in Senate, and then it had another version of it that passed the House. They could not reconcile it. So they have these bipartisan bills that have floated around in Congress. Even presently, we have the EAGLE Act that puts forward getting rid of the 7% per country cap. You have 30% of the visas allocated for nationals of other countries besides India and China, and you take that percentage down lower every year until the backlog has been met. There was another attempt in the comprehensive immigration reform where they were trying to recapture all the unused visas from 1993 each year, though they did not really explain how they were going to do that. So it's not that attempts have not been made. It's just we have not been able to reach a consensus as to, this should pass. And a lot of populations have suffered because of that. Like I mentioned, they call themselves documented dreamers, and family members of these populations, or the fact that the principal applicants can't switch jobs as easily. They would have to start the process all over again. And Congress knows this, and attempts are made, EAGLE Act being the open one right now. So I would like to also point out that this idea of recapturing visas have also come up in reconciliation talks. Like we should recapture all these green cards in reconciliation, and we're putting all of these buckets of whatever we can get in reconciliation. I want to point out that bipartisan bills out there exist to push this forward if we were to put our energy in the right place.
So the backlog obviously didn't start with COVID. We've got Congress sort of putting some solutions forward, but just unable to get through to get it signed into law to make these things easier. Teresa, I want to go to you. What do you think is the way forward on this?
So I think there's a few things that need to be done. As I mentioned, there's sort of two backlogs that we're paying attention to. One is the per country cap, which means that people from certain countries, namely India and China in the employment-based categories, but also some family-based categories like Mexico and Philippines, have extraordinarily long wait times because the demand for visas from those countries far exceeds the 7% per country allocation that they're allowed to have. So, several of the bills that Sadiksha mentioned are addressed at, basically allowing either eliminating the per country cap entirely or reallocating visas somewhat based on demand, because it doesn't make sense, I think, practically, to say the same number of visas should be available for a country like India or China or the Philippines or Mexico that has high demand for green cards versus a country like Brunei, which has a fraction of the population, many of whom are not trying to get to the United States, right? So having them have the same number of visas doesn't necessarily make sense. So we think that there's ways that can be done. The other piece of it is just adjudicative processing capacity. And that processing capacity of the government has been significantly diminished by COVID. And as I mentioned, it's not going to get caught up anytime soon. It did precede COVID somewhat. Let's think about like the asylum case backlog. Not talking about even immigration court, just affirmative asylum cases have close to 100,000 cases waiting there. People who've been waiting months and months and months for naturalizations, for employment authorizations, for petitions to be approved. And then cases in the State Department waiting months and months and months for visa interviews. So once what we've seen in the past is once these backlogs start growing, and we're adding, as we mentioned, the Afghan evacuees, we're adding, and the arrivals at the southern border, we are adding many more people into the system than we are moving out of the system by adjudicating their cases. So we have if you will, a huge inflow-outflow problem where inflow is many times higher than outflow. And until we can increase the adjudicative capacity, because we don't control the inflow completely, unless we can significantly increase adjudicative capacity in all parts of the system, these backlogs will be with us for quite a long time in just adjudication. So we have to address both halves of the system. The slow adjudication leads to the loss of the capped visas, right? If we, deal with the visa caps, we may actually have more people applying, at least in the short term. So we have to make sure we have the capacity to address. And then we have these, extraordinary migration events like the Afghan refugees, evacuees, and the arrival of people at the US-Mexico border that are not accounted for in sort of the regular order process, but are put into the system nonetheless. So, I think our system is very close to a breaking point that we are going to have to address one way or the other.
Well, and I can't remember if you even mentioned the 500,000 cases in the immigration court backlog that we also have to get through.
No. We're close to 1.5 million. Let's be clear.
1.5.
1.5 million cases in the immigration court backlog. Yeah, that's not even including that.
Well, I'll just say that, Congress has a responsibility to help with the administration of our country and our borders and maintaining these things that, we need to actually put some focus on this in Congress, that it's not good enough just to talk about it and point out the stressful situations, the photos, the crisis at different borders and the crisis in Afghanistan, but that Congress has a role to play in making sure that we can actually process these things in a way that is humane, that also protects, U.S. interests, is a way to vet things, and can make us a prosperous country, especially those family immigration and business green cards. So I think there's a lot more to do here, and it sounds like we're going to have a lot more to talk about. But for now, we'll leave it there, and it's time to get to the gavel. In this week's segment, we first look at the evolving story of the Migrant Protection Protocols, or the Remain in Mexico program, a Trump-era policy that the Biden administration ended shortly after coming into office. In last week's episode, we talked about how a federal judge in Texas ordered the Biden administration to reinstate MPP, and an appeals court in Texas refused to stay that decision. On August 24th, the Supreme Court denied the Biden administration request for a temporary stay so that they would not have to restart the program before the end of the week. Sadiqa, can you tell us a little about the Supreme Court's ruling itself and what it means for the Biden administration?
Yes. So, like you mentioned, it has put a little hold on the stay that the Biden administration had requested on MPP. I want to clarify something, though, because it does not imply that the Supreme Court has asked the Biden administration to restart MPP. It's just saying that the hold that they had asked based on the Texas order has been denied, which means that temporarily the Biden administration has to continue with MPP while the case is being adjudicated in the Fifth Circuit. And I think that's towards the end of November. So we don't know what the outcome of the case in the legality of the program itself is going to be, but it does not look good that the Supreme Court does not think that the Biden administration has a case. And, like all immigration cases are adjudicated under this, it was the APA, and it's never a surprise anymore because they're all violation of the APA. The Supreme Court does think that rescinding MPP was arbitrary and capricious, saying that the Biden administration terminated the program without, proper comment period from the public, and did not think of the unintended consequences. This is very reminiscent of past immigration adjudications as well from this court. In 2017, I believe, maybe I'm getting the year wrong, they ruled the cancellation of DACA along the same lines. They said that, it was arbitrary and capricious, and it has unintended consequences. So all of these rulings that were happening under the Trump administration, that the advocacy and the immigration groups were lauding for, is now happening under the Biden administration. And so that is very, it's serious that it can go, Supreme Court's going to rule the same across the board, I think. So relying overtly on this for executive immigration actions for the Biden administration, this might be a wake-up call. What does it mean for the Biden administration? It just puts them in a really hard place. They have said that they're going to, in good faith, try to implement this program. Now, this means, bilateral conversations with Mexico. It has another country involved. So we have to wait and see what the Biden administration is going to do about this. But this does put them in a rock and a hard place.
Yeah, it's a little bit ironic to see the Supreme Court take a stance against the Biden administration using the same one they used against the Trump administration. Well, Teresa, let's get over to you now. Let's talk about the feasibility of this. What are the logistics of restarting MPP? As Sadiqa mentioned, there is another country involved in this process, Mexico. Are they going to play along with this?
So what's interesting here, as you mentioned, is that MPP, even though it was reported to be a unilateral action by the U.S. government under the Trump administration that Mexico acquiesced to in the name of protecting migrants, they said. Mexico is under no official obligation to take anyone into its territory that's not a Mexican citizen. Just like we have sovereignty over our territory, they have sovereignty over their territory. So anything they would do in this situation would be to basically buy some sort of agreement with the United States government. Now, the Biden administration has had lots of conversations with Mexico. Vice President Kamala Harris has been to Mexico and talked to Mexico a lot. She was put in charge of the root causes issue, as you well remember. And one of the things that the Biden administration has kind of continued from the Trump administration is asking Mexico to enforce its southern border with Guatemala, which is the primary crossing point for many migrants getting to the U.S.-Mexico border. In fact, just this week, the Mexican National Guard pretty brutally broke up a caravan of migrants that was coming north. So they are continuing to do that. And at least I believe for the government of Andrés Manuel López Obrador, the Mexican president, they do see a Mexican national interest in reducing the transit of migrants through Mexico. So they believe it's in their interest. But whether or not it's in their continued interest to take migrants back from the United States, I think is a different question. In part because they're not taking as many migrants back right now. We still have Title 42 in place, which, like MPP, requires Mexico to acquiesce to receiving people back that we expel. But they have not been taking back many families because of changes in Mexican law and capacity issues they say they have in providing basically shelter and secure facilities for families, particularly with minor children. So in the last month, the majority of families apprehended at the U.S.-Mexico border could not be expelled under Title 42 and have been released in the United States. That would be the most likely population that would be put into a new restarted MPP program. But if Mexico is not allowing them back into the country under Title 42, it's not clear whether Mexico would allow them back under MPP or under what conditions. So I think there's definitely an issue here. Setting that aside, operationally, the all of the things that were put in place to allow my MPP to happen on the US side and on the Mexican side are kind of taken away right now. So we don't have the border courts available that we did that were processing MPP. The non-governmental organizations that were working with the Biden administration to help return people under MPP into the United States to pursue their claims are no longer working with the administration on that. The migrant camps and facilities that had been built and basically upgraded a lot by these NGOs, many of them had been disbanded, although we're seeing new ones come up now, like in Reynosa, Mexico, without the assistance of the NGOs, so they're still fairly squalid. And there's the ever-present issue of the dangers that these folks have been facing in Mexico from crimes. So I think operationally, it is a tough slog for the Biden administration to restart it. But, so much hinges on what Mexico will do. And I think that's yet to be determined.
Well, and so finally, I just want to wrap up this section just on, you've been a proponent of legislation over litigation. Obviously, this is another situation where the courts are ping-ponging back and forth between seemingly to go to the right and to the left based upon who's making the case. How does this ruling further your argument that proponents of immigration reform really need to focus their energies on legislation?
Well, I think it goes back to something you said about the Supreme Court ruling and basically the Texas court case, right? So the Texas judge used the exact same case that the Supreme Court said to the Trump administration, you can't end DACA because you didn't do it right. They use that exact same case to tell the Biden administration, you can't end MPP because you didn't do it right, right? So, it's kind of, be careful what you wish for. When precedents are set in the judiciary, they apply to every president of every party going forward. And they apply equally, as Sadisha said, APA applies equally to, policies, whether you like them or not. And I think the other thing to bear in mind is that we are facing a judiciary that was very much changed under the Trump administration to be more conservative, and specifically the Supreme Court. So that the litigation actions that had been started against Trump, can easily come back to bite advocates when it's used against them. Congress has the ability to address this if they choose to by changing the law. MPP is a section of immigration law. And that section can be changed. And if Congress changes the law, then these arguments about whether or not you end a program correctly don't matter because you no longer have the authority to have that program in the first place. So, again, the long-term solution, you see these short-term victories that end up being Pyrrhic victories when they're reversed the next time around. The long-term solutions have to come from Congress. You have to have legislation, which means we have to figure out how to get Congress to work together to do it.
Well, look, I think that we've had about as much download as my mind can process today. I'd like to thank Ruth Wasem, Sadisha Nepal, and Teresa Cardinal Brown for helping me and our listeners learn so much today. And that's going to wrap it for this episode of This Week in Immigration. One last time, a reminder to rate, subscribe, and review this podcast on Apple Podcasts, Stitcher, Spotify, or your favorite podcast platforms, and share it with your friends and colleagues. You can also find more information on all the issues we discuss here on the show at bipartisanpolicy.org/immigration. You can follow us on Twitter at BPC_bipartisan. I'm Blake Johnson. This Week in Immigration was created by Teresa Cardinal Brown. The executive producer of This Week in Immigration is Teresa Cardinal Brown. This week's episode was written by Teresa Cardinal Brown, Sadisha Nepal, and myself. Ethan Plotkin produces and edits our show. The executive producer of BPC Podcasts is Lucy Manning. See you next time on This Week in Immigration.